Frequently asked questions about permissible closed sessions of the California State Legislature. So first, does the state constitution provide when the California Legislature can meet in closed session? Yes, and it does so in Article 4, Section 7C, again, of the California State Constitution. So what does the California Constitution provide regarding closed sessions of the legislature? It says that there are specified instances, despite or notwithstanding other open meeting provisions of the state constitution, in which closed sessions may be held by the legislature. The limitation is that these closed sessions may be held solely for the specified purpose or purposes. So, what are those purposes for which the California legislature may meet in closed session? It may meet in closed session for the following 5 reasons. First, to consider the appointment, employment, evaluation of performance, or dismissal of a public officer or employee. B, to consider or hear complaints or charges brought against a member of the legislature or other public officer or employee. Third, to establish the classification or compensation of an employee of the legislature. Fourth, to consider matters affecting the safety and security of members of the legislature or its employees, or the safety or security of any buildings and grounds used by the legislature. And fifth, to confer with or receive advice from its legal counsel regarding pending or reasonably anticipated or whether to initiate litigation when discussion in open session would not protect the interest of the House or committee regarding the litigation. Are these permitted closed sessions similar to those permitted of other state legislative bodies? Yes, and these authorized closed sessions are actually similar to exceptions allowed for other public bodies at both the local and federal levels of government. Is the public notified of these closed sessions? Yes, the legislature is required to provide to the public reasonable notice of the closed session and the purpose of that closed session. Are there any other instances of permitted closed sessions in the California legislature? Yes. Section 7C of Article 4 of the state constitution says that a caucus of the members of the Senate, the members of the Assembly, or the members of both houses, which is composed of the members of the same political party, may meet in closed session. This is the most common use of an authorized closed session. The Democratic or Republican legislators in either house meet together, usually once a week during the legislative session, and also they're used from time to time during floor sessions, off the floor, of course, to discuss timely issues before the legislative body on the floor.